in the family court, they often sit. In fact, usually sit at the tables because there's about 8 lawyers all at once. And the cameras are fixated there. And he practices a lot in family court. And so sometimes those lawyers don't get in the camera frame. But go ahead. You can address costs first.
Addressing the issue of costs, I'd like the court to just consider the asymmetrical nature of this situation. This is handled in a civil way, but it is a governmental entity, in my opinion, addressing a liberty interest. I'd like the court to consider that when deciding whether or not to award costs. It is clear that representation has been beneficial to make this move through. We're here today, the hearing's over. So the prejudice abates today if there is any anyhow, but I don't think it's necessary to award costs. The township is the plaintiff here. The township brought us here to begin with. I don't think there's a huge string of lawyers jumping up and down saying, hire me for your civil infraction, please. So here we are. Mr. Mayor hired me. I got in when I got in. We did have communications about, hey, does this date work? And does this date work? And guess what? The month of June sucks for everybody. You are gone. I'm gone. They're gone. We're all gone all the time. If we could have had a next hearing date the next week, I'd have gladly done it. But it just doesn't work that way with all of our schedules. So that's the court to just consider the nature of this and the reality of whether or not Mr. Mayor was attempting to delay, or I was attempting to delay, or being nasty in any way, or whether this was a matter of trying to get in and handle this. Could I have done a bit better at making sure that that day was clear ahead of time before engaging with Mr. Mayor? Yes. But we have attorneys here and they have clients and they have cases and they have to be at them. So I'd ask you just to consider that when ruling on the costs issue. Moving on. For closing, there are a lot of things that the court heard today that show that it may be possible that despite this parking ordinance saying on the tin that it's a police power, when you open up the can, it's a zoning ordinance. They don't want you using your property in a way that affects the real estate market, that affects the development. That Mr. Coolman even testified when I asked him about it. Well, number one, it's a big pain in the neck to pass a zoning ordinance. We can get a police power one done ASAP. There is case law in Michigan about whether or not a township uses a police ordinance to subvert the more complicated zoning ordinance process. I would suggest that that may be what happened here. Mr. Coleman's testimony was also that there was a fear that if they used the zoning power, Tony would be grandfathered. And then they're stuck with this stuff. They wanted to get it done right now. So there was a safety violation. There was a near death that was mentioned in one of these reports and then was never elaborated on. Nothing else ever came of that. Nobody ever really heard of it, but boy, that does do a really good job of tying this ordinance to health, safety, and welfare. Our property values welfare, yes, it's settled that that is a component of that. Nobody wants a crack house next door, and a town can pass an ordinance to that effect. I think the court also needs to consider, though, that Mr. Mayor sure didn't build a crack house in North Meadows. He built what may be the biggest house in North Meadows. And I get the sense it's a little like living next to Kid Rock's mansion. Sure, it's big and fancy, but we just don't like it. And because we don't like it, we just don't like this. And they push on Mr. Mayor to the point where in his testimony, he declares that there's just been an issue getting anything done because of the stress of litigation and trying to handle it on your own, going through another law firm and burning through that bridge that I imagine is quite stressful. So coming back, I believe that the court could consider this police power ordinance to be, although it says what it is in the ordinance, it isn't really what it says it is. It's a zoning ordinance. As far as the zoning ordinance violation regarding a home-based business, industrial. If you look at the definition in Merriam-Webster's Collegiate of Industrial, it's of or relating to industry. When you follow that a little bit farther, industry, I think I'm an industry I'm producing things from time to time. I think grandma with a sewing machine, kids with a lemonade stand, they might all be barred by operating these home-based businesses. You know, if you can't knit doilies inside your home because you have an article of industry known as the sewing machine, this starts to look like maybe this is a little overbroad, and maybe it takes away your opportunity to use your property productively in a non-offensive manner. So I'd ask the court to consider that definition of industry as an overbroad articles of industry used in two different places in the zoning ordinance as an overbroad conception of how a township ought to be able to regulate a home-based business. We also heard from Mr. Coolman that, you know, he doesn't really know what it means. That's no skin off his back. He didn't write the ordinance. I don't know what it means either. And that's the problem. And the problem you get is you have an enforcement officer who's left to just make calls about vagaries. And when a law is too vague that a person of ordinary prudence may not know just how to obey it, I don't think this court has the ability to enforce that law. And there's a sense that just about anything you do in Lockport Township could be a violation. If I'm taking a phone call from a client while I'm walking around Lockport Township, am I committing a problem? I don't know. Seems that I might be. Also, there's just too much conduct that is prohibited by the zoning regulation, and there's too much regulation of conduct that ought to be regulation of property going on here as well. I also would state that I think it's fair to argue that the Michigan Vehicle Code, as I referenced earlier in this proceeding, preempts the local regulation. Now, the Michigan Vehicle Code doesn't preempt local regulations on everything. Townships can have their own vehicle ordinances, but when you get into commercial vehicles, I think it's quite uncommon for a township to have commercial vehicle ordinances. I think that those are very highly regulated at the state and federal levels, and it may be such that the Michigan Vehicle Code definition preempts the township ordinance and creates an exception for a personal use vehicle such as Mr. Mayer's camouflage semi. So I'd ask you to consider those things as well. The other thing is we did hear a lot of testimony. There's work being done. You have this problem with this construction vehicle storage ordinance prohibits construction vehicle activity. On reading the ordinance, it seems as though if somebody wanted to get cable internet hooked up, they might have a problem if the company brought a trencher out because maybe it's not permitted work. But boy, that looks like a construction vehicle. It may be overbroad as well. So I'd like the court to consider that. And I think that there's something just very clear, and Your Honor even said it, that they found Tony. They listed off all the property they alleged Tony has in his yard. They passed the ordinance after telling him, you're not in violation. I'm going to go get an ordinance that you're going to be in violation of. Is that how legislation works? Often it is, right? We didn't know to ban meth until we had a meth problem. But there has also been testimony that this has never been enforced against anybody else. I don't think Doug had gone out on one of these in 5 years. Also suspect that Doug doesn't normally do these. Mr. Hayden usually does these, but for whatever reason, Doug's doing this one. And this is not to cast aspersions on Mr. Coolman. I feel he's just following orders here. So that's the court to consider all that I've laid out here, the whole picture of this thing, and make a just and wise decision. Thank you.
Any final rebuttal?
Thank you, Your Honor. Just briefly on the issue of costs, Mr. Truckee brought up the whole idea of uneven power of the parties, and that this court should consider that. And just to be clear, we're not saying that there was anything nasty or gamesmanship going on that caused the delay. We're simply saying that because the final pretrial took place on April 24th and legal counsel was not retained until less than a week before the formal hearing, that's the delay that caused the township to incur the costs, because we were not able to then get a stipulation to a new date, and that's what it was. So it's not, it has nothing to do with the power of the parties or anything like that. It has to do with the timeline of being of retaining legal counsel and how that then transpired in that week before the formal hearing. There was some argument about the police power ordinance and whether or not it's actually a zoning ordinance. This is a red herring, Your Honor. The ordinance plainly regulates activities on the property. It does not regulate specific uses or set forth specific zoning districts or set forth specific setbacks. It's nothing like that. It relates to activities on the property. It applies to all residential platted properties, regardless of specific zoning characteristics or zoning districts. So it's broadly applicable, and it's not, it has nothing to do with uses of the property. It's generally related to activities conducted on the property. It's no different than a blight ordinance or a junk vehicles ordinance or a nuisance ordinance, a dangerous buildings ordinance, or even a sign ordinance, which are all commonly put into police power ordinances. In fact, in the Adams case that from the Michigan Supreme Court that I cited in my opening, that case pertains to a sign ordinance in which the court found that it was a sign ordinance that was deemed to be a police power ordinance. Now, if you look at communities across the state of Michigan, it's very common for sign ordinances to also be put as zoning ordinances. And so sometimes there's certain things that can touch on both. This is not one of those. This is one that's plainly within the police power realm. It pertains to activities on property, not to land uses. As far as the arguments about overbreadth or overbroadness of the certain provisions, Mr. Truckee keeps bringing up this industrial equipment provision, and that the use of the term industrial is somehow overbroad in this context, with no reference to any of the other requirements for a home occupation. Now, what about the fact that it must be completely confined within a dwelling, or the fact that the fact that it must be completely confined within a dwelling, or the fact that there's no permits even for a home occupation that have been issued in this case. And finally, I think it's clear that this is not compatible with the residential character of the community and of the neighborhood and of that particular parcel, which is also a requirement of a home occupation. So we can debate this term of industrial equipment as much as we want, but ultimately it doesn't address many of the other requirements for a home occupation, most notably being that it must be conducted within the dwelling, and that's not the case here. Preemption of local regulations was brought up. Some claim that the vehicle code it may or maybe it does preempt the zoning authority in this case. We've had no authority on the record of that. There's been nothing stated that is even close to that, and I would say that that's another red herring in this case. Finally, there was a brief mention of if you have no permits, maybe you can't have any work on your property. Like you couldn't even have a cable truck come out and install equipment. That's not true. The ordinance doesn't allow parking or storage of this equipment in motor vehicles. If it's in use and it's during the day, it's during working hours, you're not going to draw in a complaint because of that, because of routine maintenance. And two, it's not parked or stored on the property, so it's not applicable. Again, another red herring. And then finally, there was mention that Doug said that there's been no enforcement of the vehicle storage ordinance since the citation was issued to Mr. Meyer. That was not what was testified to on the record. He testified that he himself had not issued a citation under the ordinance since the one issued to Mr. Meyer. There may have been ones issued by the township generally or by Mike Hayden, the other code enforcement officer. I just thought that was a mischaracterization of what was testified to. So we have nothing further, Your Honor.
Thank you. That last argument comes up often. I'm the zoning judge. I offered to give zoning to Judge Patterson. He said, fine, you can take custody cases with children. I said, no, thank you. So I'm the zoning guy. And occasionally I'll do some circuit court case zoning matters as well. And the defendants often say, why are they picking on me? There's 8 other parcels in the township that are as bad as I am. There is some hard to define defense of that, but not only in this township, but most of them. They don't do anything unless there's a complaint. I can think of several other parcels in Lockport Township that are in violation of this standard. but apparently nobody's complained about them. People have complained about yours. The township board is a constitutionally constituted entity. It isn't just a group of people that are mad about this. They're elected in a partisan public election to serve as the township board. And they have broad authority in a number of areas, including zoning. And then there are people that operate under the authority of the township board, like Mr. Kuhlman, like the planning commission, like the zoning board of appeals. They aren't elected, they're appointed by the elected body. So this isn't just a group of people that didn't like this. I guess there is such a group, but they went to the township board, which represents everybody in Lockport Township. And they're spending the money of everybody in Lockport Township. To litigate this issue.